Welcome back. Okay, let's dive into this explainer. Today, we're dissecting a truly staggering legal bill, one generated from arguably one of the most high-stakes, politically charged constitutional battles in South African history. We're going to look under the hood of a massive court judgment, specifically focusing on how the highest court in the land figures out what's actually fair when one side is legally forced to pay the other's legal fees. So here's our roadmap for this session. We'll start with the Million Rand legal bill, move on to the unprecedented constitutional showdown, cover the rules of repayments, the price of preparation, a hidden billing mistake, and finally wrap it up with the final verdict. Let's get to it.
Section 1. The Million Rand legal bill. To truly wrap our heads around the mechanics of this legal showdown, we first need to grasp the sheer, eye-watering scale of the bill that was handed to the court for approval. Just look at that number. Over 1.1 million rand. Following a massive legal victory, the successful party submitted this astronomical total for the losing party to pay. Now keep in mind, in the late 1990s, this was a monumental sum for a legal costs order. It immediately set up these immense financial stakes and kicked off a fierce debate about what actually makes a fee reasonable in such an extraordinary case. Now, what's really interesting about this is exactly where all that money was going, because the bill wasn't just evenly split down the middle. About our $234,000 went to the instructing attorney's fees, but the vast majority of it, over our $904,000, was for disbursements, which went almost entirely to the three advocates or counsel who actually argued the case. This massive disparity right here, that became the absolute central battleground of the whole taxation review. Moving on to Section 2. An unprecedented constitutional showdown. To understand why these advocates felt justified in charging nearly R1 million, we have to look at the exceptional and genuinely historic nature of the original case that required their services in the first place. The timeline of this litigation was honestly pure chaos. It started in the High Court as an urgent application that just spiraled into 18 days of oral evidence. In a completely unprecedented legal moment, the sitting president of the Republic of South Africa was ordered to appear in court and was actually cross-examined on accusations of perjury. Following an adverse ruling, the case went to the Constitutional Court. But before the appeal even began, there was a shocking 3-day application attempting to recuse the entire Constitutional Court bench. Once that was finally dismissed, the appeal argument itself took 5 full days. So as you can imagine, this case was an absolute titan of paperwork. The High Court judgment alone was 1,159 pages long. It was so massive that law publishers literally couldn't print it in full. The total court record exceeded 6,600 pages of affidavits and transcripts. The legal team had to navigate this daunting volume of files just to prepare their constitutional arguments. It's really important context because it justifies a significant amount of intense, time-consuming preparation. Section 3. The rules of repayment. So, the winning side clearly had a massive team and actual mountains of paper. But when the dust finally settles, who pays for all of this? Let's transition to the actual legal rules governing repayment. So the crucial point here is that this dispute isn't about what a lawyer charges their own client. That's a totally private matter. This is about party-in-party costs, which is what the loser is legally forced to pay the winner. And the person who gets to decide what's fair, they're called the taxing master. They review the bill and trim away anything they think is excessive. The overarching legal principle here is indemnification, which is brilliantly captured in this historical quote by Chief Justice Innes. The whole goal is to ensure the innocent, successful party is reasonably compensated for being dragged into court. However, and this is key, it is not a blank check. The loser's only required to pay what is strictly necessary and proper for the attainment of justice. They're not paying for a legal team's extravagance or overcaution. Section 4. The price of preparation. This principle of reasonable indemnification brings us right to the core dispute. How did these specific advocates actually calculate their massive fees for preparing this mountain of a case? And this brilliantly illustrates the two competing billing philosophies at war in this case. The winning advocates billed on a rate-per-time basis. That means they logged hundreds of hours of preparation and charged an hourly rate for every single one of them. But the losing side, they argued this was entirely wrong for an appeal. They insisted the court standard is a composite first-day fee. Basically, a single, flat, all-inclusive fee that covers all preparation and the first day in court, followed by much smaller daily refreshers. Historically, the courts have taken a really harsh stance against purely hourly billing in party and party taxations. As Chief Justice Corbett noted in a previous ruling, blindly paying by the hour basically puts a premium on slow work. It risks punishing the losers simply because the winner's lawyers decided to take their time. Time spent is definitely a pointer, sure, but it absolutely cannot displace an objective assessment of the actual value of the work done. Recognizing that this case was, frankly, extraordinary, the taxing master initially tried to strike an equitable balance using these 5 specific criteria. She looked at the immense complexity of the constitutional questions, the sheer 6,600-page volume of the case, prevailing fee levels, inflation, and the need for fair compensation. She did reduce the R1.1 million bill slightly, but she still allowed over R1 million. Section 5. The hidden billing mistake. Unsurprisingly, the losing side appealed this decision, sending the bill directly to the Constitutional Court for review. And that is exactly when a dramatic twist occurred. The court discovered a fatal flaw buried deep in the paperwork. The taxing master had spent hours and hours debating specific hourly rates and per-page fees. The lawyers had argued passionately about old legal precedents. But what was the fundamental error hidden in plain sight within this R1 million bill of costs? Any guesses? Well, Justice Kriegler and the Constitutional Court realized the bill had wrongly rolled 2 entirely separate cost orders into one single invoice. Remember that 3-day recusal application targeting the judges? The court had ordered that Dr. Louis Light alone was liable for those costs. But for the main appeal, Dr. Light and the Gauteng Lions Rugby Union were jointly liable. By submitting one consolidated bill, the winning team was unjustly saddling the Rugby Union with a massive debt for a recusal application it had absolutely no part in. Wow! Which brings us to Section 6, the final verdict. Because of this massive fundamental error, the taxing master's initial approval of the bill had to be completely set aside. The Constitutional Court had to step in, untangle the whole mess, and restructure the bill to ensure absolute fairness for everyone involved.
Let's move to the numbers and see how this builds toward the final resolution. First up, the court fixed the attorney's document reading fee. The losing side argued the attorney should only get R17 per page for reading that massive 1,159-page high court judgment. The court, however, disagreed. They stated that because of the extreme importance and complexity of the document, the higher rate of R27 per page was entirely justified, which brought the total to a R25,650 allowance.
Next, the court tackled those massive advocate fees. Acknowledging the extreme complexity, the constitutional importance, and the thousands of pages of reading, the court decided that while hourly billing wasn't appropriate, a standard flat fee just wasn't enough either. So they capped the senior counsel's allowed fees at R240,000. This struck a really vital balance. It was generous enough to reflect the case's unique difficulty, but strict enough to protect the loser from paying for literally every single hour the senior advocate spent sitting at their desk. For the rest of the team, the court then applied a standard legal formula for the 2 junior counsels, capping their allowed fees at 2/3 of the senior's rate. That resulted in exactly $160,000 for each junior advocate. Finally, the court provided a really pragmatic mathematical formula to solve that hidden billing mistake we talked about earlier. They ordered the taxing master to set aside the single bill entirely, because it was pretty much impossible years later to figure out exactly which hours were spent on the appeal versus the recusal. The court mandated a rough but fair split. 4/5 of the total allowed counsel fees would be allocated to the main appeal, meaning Dr. Lute and the union share that cost. The remaining 1/5 was allocated to the recusal, for which Dr. Lute was solely responsible. And that, folks, is how a $1.1 million legal bill was forensically dismantled and reconstructed by the highest court in the land. It leaves us with a truly fascinating dynamic about the mechanics of the legal profession. When the stakes are at their absolute highest and millions are on the line, is hourly billing truly the best way to measure the pursuit of justice? Or does it, as the court warned, simply put a premium on slow work? It's definitely something to think about next time you see the hidden gears of a massive legal showdown turning. Thanks for joining me on this explainer, and keep questioning the details.